Thank you. Before I begin, I do want to make one comment that we're going to talk a lot about the Executive Office for Immigration Review. And last week, unfortunately, the former director of EOR, Juan Osuna, passed. Juan was a friend of mine for more than a decade, and he was a good public servant, and he died unexpectedly at a rather young age, and so I did want to note his passing before I began. On June 1st, the Government Accountability Office issued its long-awaited report on the management of EOR. That report revealed a significant decline in the ability of the immigration courts, which are a component of EOR, to complete cases over the last 10 years. GAO found that the Immigration Court's backlog, that is, cases that are pending from previous years that remain open at the start of a new fiscal year, more than doubled between FY 2006 and FY 2015. Specifically, GAO found that the backlog rose from about 212,000 cases pending at the start of FY 2006, when the median pending time for those cases was 198 days, to 437,000 pending cases at the start of FY 2015, when the median processing time was 404 days. Unfortunately, these backlogs have real-world consequences for both the government and for the aliens who were affected. As GAO found, quote, some immigration courts were scheduling hearings several years in the future. In fact, GAO reported one court had master calendar hearings, which is your initial arraignment in a immigration context, scheduled in May 2021, more than 4 years in the future, while one court had scheduled individual hearings, which we also call merit hearings in immigration cases, when your case is finally decided, 5 years into the future, until February of 2022, which means that you aren't going to go to court for another 5 years. These delays mean that the government may have to wait years before they can actually get a removal order for an alien who is prima facie deportable and who has no relief. So basically, that person gets to stay in the United States during the period of time of the backlog. As importantly, for an alien who is eligible for relief and who may be interested in bringing relatives to the United States, the alien also has to wait, that period of time until a final order can be issued. This can be especially problematic for an individual who is an asylum claimant who may be able to bring relatives to the United States out of harm. By and large, the backlog has not resulted from an increase in new cases over the past 10 years. In fact, new case receipts declined by 20% from fiscal year 2009 to about 202,000 new cases in fiscal year 2015. So backlogs increased, but we've actually seen a decrease in new cases. What did increase during this period of time were other case receipts. Those are motions to reopen, motions to reconsider, and recalendar, which increased 86%. Motions to reopen and reconsider are generally filed by aliens who are under orders of removal, and motions to recalendar are filed in matters that are administratively closed, and Larry may touch on that a little bit more. But that is when a case is taken off of the court's docket. So these cases actually are, cases that have more or less been decided or are pending out there that are just lumped, again, back onto the backlog. While new case receipts fell, the immigration courts were actually completing fewer cases annually, and this is where the delta comes in. Incredibly, GAO found the number of immigration court cases annually declined by 31% from fiscal year 2006 to fiscal year 2015, from about 287,000 cases completed in FY 06 to 199,000 in FY 2015, even as the number of IJs increased over the whole period by 17%. More judges, fewer cases getting decided. The other issue is that many of those so-called completed cases were not actually cases completed on the merits. Those cases were administratively closed, effectively taken off of the court's docket, but no resolution was ever reached in that. Merits decisions were originally 95% of the total in FY 06. They went down to 77% by FY 15. So effectively 23% were just sort of pushed off to the side for the time being. The question is then, if the number of judges increased and the number of new cases filed decreased, why is the backlog growing? According to the GAO, The reason is that it's taking longer for IJs to issue decisions. Specifically, the average period between the filing of a charging document and an IJ issuing a decision grew more than fivefold between FY06 and FY15, with the median initial completion time for cases increasing from 43 days in FY06 to 286 days in FY 2015. All of this, however, begs the question of why it's taking so much longer to complete immigration cases. According to GAO, this is partially a result of a 23% increase in continuances. So you go to court, you ask for an attorney, you ask for time to find an attorney, your case gets continued. You ask for time to consider relief, your case gets continued. You ask for time to file an application, your case gets continued. These are the continuances that take place. There's also been an increase in the number of cases with multiple continuances. Significantly, the number of cases with 4 or more continuances increased from 9% in FY 2006 to 20%. So 1 out of 5 cases had more than 4 continuances or more by FY 2015. There's several reasons why the immigration courts are in this position, and several reasons why the court should begin to get a handle on and decrease the backlog in the next few years. The first is resources. Simply put, there are too few people like Larry for the number of cases that ICE has filed with the immigration courts. Today, there are 334 immigration judges handling more than 610,000 cases, or about 1,800 cases per judge. When a judge has a docket that large, cases must be set out for an extended period of time, and it often becomes more efficient to grant a weaker motion to continue than it is to enable the judge then to focus attention on cases that are ripe for decision. The good news is that the Attorney General has recognized this problem and has promised to hire 125 new judges within the next 2 years. And in fact, Attorney General Sessions has begun to deliver. 21 new judges have been sworn in just since June the 16th of this year. Another major reason for the backlog was the so-called surge of unaccompanied alien minors and members of family units that began in FY 2014. In the course of just 1 year, between FY 13 and FY 14, the number of minors apprehended increased by 76%, and the number of aliens and family units increased by 360%. While many reasons for this increase have been advanced, I believe the most significant was word of mouth. People called back to the home country and said, look, I came to the United States, they let me into the United States, and they released me. Part of it was also lies told by smugglers who said, if you come to the United States, you're going to get a permission to remain in this country. Smugglers want to make money, and there's no better way to do it than by promising something to potential clientele. These new cases strained the court's dockets for 2 reasons. First, EOR decided to prioritize those new cases, so they pulled judges off of pending cases and put them on cases involving children and family members. So there were a bunch of cases that were ripe for decision that had to be pushed back because the judges were reassigned. The other reason is that cases involving children and family members are generally more complex than cases involving single adult males. It's been my experience that most single adult males have come to the United States to work, and if they're caught and detained, they just go home. They take an order of removal or voluntary departure. When you're talking about a minor, however, the minor will ask for time to have a hearing. Depending on the age of the minor, you may have to grant multiple continuances in order to find a lawyer. So, also, the claims are more complex. The asylum claims that are advanced by these individuals are generally more complex than asylum claims, for example, made by single adult males. Similarly, the Obama administration's deferred action programs for aliens who had arrived illegally as minors and for the parents of U.S. citizens and lawful permanent residents led to multiple continuances as aliens requested time to explore such relief and to apply for the relief. And again, that just slowed up the docket even more. These weren't the only Obama-era policies to have a deleterious effect on the backlogs in the immigration courts, however. Beginning in 2011, ICE put in place prosecutorial discretion guidelines to prioritize certain cases for removal. And then they did something really interesting. They told all of their attorneys to go through all of their pending cases to find the cases that were priorities so that they could, make sure that cases that weren't priorities weren't on the docket. So basically what that did was it took attorney time that could have been spent completing cases and put it to reviewing cases, which just slowed up the process even more. This effort reached its apex in a November 20th, 2014 memo from Homeland Security Secretary Jay Johnson on policies for the apprehension, detention, and removal of undocumented immigrants. That memo strictly set limits, strictly limited the cases that were to be prioritized for prosecution, increasing the court's caseload, and directed ICE attorneys to join in on motions in those cases. So again, the attorneys had to review all their files, and they would have to talk to the other attorney, and they would file motions to, administratively close or in order or to, bring the case forward in order to have it decided. It was a mess. These policies also made it clear that the administration did not consider the removal of any, except for the most serious of cases, to be appropriate, placing IJs who were sworn to uphold the law in a bind. It also gave aliens with non-meritorious claims incentives to fight their cases. And this clogged the courts even more as those non-meritorious cases continued. People who normally would have taken an order of removal asked for continuances, hoping that their case would be one of the ones that would be taken off the docket because it wasn't a priority. The new administration has taken a different tack from the Obama administration. President Trump has made it clear that he intends to enforce the immigration laws against all those who are removable, and so have his subordinates, and to expand detention. This both offers more clarity to IJs and removes incentives for removable aliens who do not have relief to fight their cases. And in fact, we've seen that the number of orders of removal issued by EOR increased by 27.8% between February 1, 2017 and July 31, 2017 compared to the same period in 2016. So again, more people are being picked up who don't have relief and are actually being ordered removed by the courts. Two other factors have also increased the backlog. Activist federal court judges have further complicated the already tortuous process that IJs must follow to ascertain whether certain convictions render aliens removable. And in the Ninth Circuit, a series of decisions have increased the number of aliens who are eligible for relief. These decisions inhibit the ability of IJs to make timely judgments, they encourage frivolous claims, and they spur remands and reopening of settled cases. I fully expect that Attorney General Sessions will more vigorously litigate cases before the federal courts than his last two predecessors did, resulting in more bright-line decisions that will provide better guidance to the IJs, and that'll bring down the backlog. Finally, IJs need better guidance when it comes to denying continuances. Some aliens seek multiple continuances for counsel. Some attorneys seek multiple continuances for case preparation and for filing applications. There's little downside for an immigration judge who grants numerous continuances because such orders can rarely be appealed. They're interlocutory decisions, and the Board of Immigration Appeals doesn't generally favor taking those. However, there's tremendous reputational damage that can occur when a motion to continue is denied. In such a case, it is possible that the Board of Immigration Appeals or a reviewing court could find that the IJ denied due process to an alien by denying a continuance, even in a case where multiple continuances have already been granted. On July 31, the good news is EOR issued a Operating Policies and Procedures Memorandum, also known as an OPPM, to curb the number of continuances by providing such guidance. I fully expect that Attorney General Sessions will follow up on this and use his certification authority to issue decisions that will help to clarify better when judges should and should not grant continuances. In summary, the Immigration Court backlog is too large. In the short run, I expect that backlog to increase as the Trump administration seeks the removal of aliens who have little to fear, who had little to fear from ICE under the prior administration. In the long run, however, I believe that the President's policies and those of his subordinates will reduce the backlog to a more manageable level. Thank you.
Thank you.